hard
Good morning.
time.
Oh, Nina.
Yeah, it's Nina.
Good morning.
Morning.
Good morning.
Good morning.
Okay, some people are having difficulty logging in. Let me see. I don't know what.
Yes, it says that it's a current meeting.
Says it's what?
That you are
Yeah.
hosting a meeting, hosting another meeting.
Oh, that's weird.
Let me pause that.
Perfect. Okay, so again, sorry for the inconvenience, you guys. It was not the internet at work. I was trying to do it from home, and my internet, thank you, Frontier, is down. So I flew to the office, and here we are. So today and for those of you that don't know me, Karen Betancourt, I'm the branch manager at the Westlake office, and we're going to be going over the listing contracts today. So I'm going to go ahead and share my screen. And we're all good, Chris, right? You can see everything?
Yep, and I encourage any questions, place in the chat, and I'll monitor the chat box for Karen while she's teaching.
Perfect. So hopefully all of you are on ZipForm Plus, the broker edition, which gives you the ability to brand everything. You see the Century 21 Everest up in the corner. The other nice thing about it is that it pulls in all of the forms that you need to do your listing contracts automatically. When you go and put in a new listing, it also pulls up the addendums for the company. And as anything gets updated as far as company addendums, it will automatically pull in the most recent. So definitely a big plus to go into ZipForm Plus Broker Edition. If you haven't already done that, see your manager so that you can go ahead and get signed up on it. Some of these forms are a little redundant from yesterday, so I'm just going to highlight the ones that are and then get into the ones that are really applicable to the listing agreement. So the first one obviously is the disclosure regarding real estate agency relationship. This is the seller's brokerage firm to seller. So that line right there at the top tells you which one you need to use. If you're confused at all, just look for the one that says seller's brokerage firm to seller. So this is disclosing the agency relationship between the listing brokerage, Century 21 Everest, and the agent with the seller. This is one of the first forms that you should have your client sign, by the way. If you're ever in a situation where you're in a procuring cost situation, one of the things they're going to look at is when did the client sign the DA, which is what the short is for this form. So that is something that you should do very first before you have them sign any offer, any listing paperwork. So first form, and basically it just explains what that relationship is. Make sure that you mark it appropriately at the bottom if it's for the seller and have the seller sign it. And of course you need to sign it as well. Okay, the second one is the Fair Housing and Discrimination Advisory. Fred went over this one yesterday as well. This is such a hot topic right now as it relates to real estate, and you're just going to see more and more and more about it. Our current president is really focused on fair housing right now and discrimination, and so we are going to be really watched carefully. Chris, did Fred go over a couple of the examples of what on here at all? Do you know?
Yes, he did yesterday.
He did. Okay, good. So I just wanted to make sure. I mean, some of the silliest things that you wouldn't think could be considered discriminatory can be. So when you're writing those remarks on your listing input and MLS, just be really careful what you're putting in there and how you're wording things, because we're going to be looked at much more closer in the years to come as it relates to this. So fair housing, that is the second form that has to be done when you're taking a listing agreement.
Hi, Ava.
The third one is, if you can just mute, that would be great. Thank you. The third one is possible representation of more than one buyer or seller, disclosure and consent. Again, This is one that is also done with the purchase agreement that Fred covered yesterday. And it's covering the fact that we could actually be representing the buyer and the seller and making the seller aware of that. And just a note, I'm sure Fred mentioned it, dual agency as it pertains to our company is any office within Century 21. So if I'm representing the seller and, Fred in Santa Clarita is representing the buyer, it's a dual agency. Even though we're different offices, we are the same brokerage. So it's going to be dual agency. A lot of agents get stuck on that one and think because it's a different office, it's not dual agency, but it most definitely is. As long as it's agents underneath the same brokerage umbrella, it's considered dual agency. Again, seller signature, your signature, and then wire fraud and electronic funds transfer advisory. Although this is really more pertinent to buyers when they're wiring in deposits, it still applies to sellers because hackers get in and get information, and all sorts of weird things happen. We've seen it in escrow, and we've seen there's one escrow company in town that I think about $40,000 worth of deposit funds were sent to the wrong place because the buyer did not pay attention to what he was doing. So those are all forms that you saw yesterday if you were in the contracts. If not, they're pretty, same ones we've had for years and years and years. Just make sure you read them and you understand them. The residential listing agreement is what I'm going to get into next. But before I do that, I want to just pull up two things here. So I want to pull up first Clerk Co-op for CSMAR. So CSMAR is the Canal-Simi Moore-Park Association of Realtors. Not all of you belong to that one. You may belong to SRAR, which would fall under CRMLS. So clear cooperation is something that came out, it's probably been over at least a year now, by NAR, and it is something that our MLSs do adhere to. And most MLSs that fall underneath the NAR, all of them adhere to clear cooperation policy. And the purpose of it was because it was thought that consumers weren't fully being, it wasn't fully being disclosed to them how their home was being marketed, and also just clear cooperation amongst all brokerages underneath that umbrella. So this is a cheat sheet that we have. We also have one, I'm going to pull it up in a minute, for CRMLS. But basically, when you take a listing, you have three options. You have an option to make it an active listing, which would be just a normal listing, where you go and fill out the paperwork and you submit it and it goes live right away. The second one is coming soon, which is where you also have to turn in the paperwork, and it will show in the MLS, but it does not show out to the public on the, like Zillow on that. And then there is Office Full Exclusive. An Office Full Exclusive is for use within our brokerage only. So when you take an office exclusive, you can only show that property to agents within the Century 20 Everest brokerage. Again, it's not just the Westlake office, but any agent within our brokerage. When you're an office full exclusive, you can make the property available for showing to any of our agents, but you cannot make it available to agents with other companies. So this is kind of a cheat sheet on the coming soon. You cannot show the property. On active and full exclusive, you can show the property. On public marketing, on coming soon and active, you can do public marketing. On full exclusive, you cannot do public marketing. So you really need to look at what your seller wants and be able to explain these three options. That's the best way to do it, is here are your three options. Which way do you want to do it? And what's our sales strategy in doing it? So that is a cheat sheet for CSMAR. And then there is also one that is much more detailed for ChrisNet. And Chris will send out these ones to you, everybody, tonight when she sends out the contract forms for the class tomorrow. So this is the one for ChrisNet, and VCCAR and SRAR will fall underneath ChrisNet. So this is very detailed. I mean, it covers everything from broker caravan to really itemizing public marketing, flyers, postcards, etc. So again, you know, they have a cheat sheet as well that you can use. So we'll get both of those out to you tonight. So let me just get out of this one and go. So now we're going to go into the listing contract. Okay, so exclusive right to sell. Obviously, you're going to fill in seller name and company. You're going to give a beginning date and an ending date. All contracts need to have beginning and ending date. Usually, we want to take those for, you know, preferably no less than 6 months. In this market, things are flying off the shelves, of course, but, you know, that market could turn tomorrow, and you don't want to take a listing and have a 1 or 2 month listing and have it expire with the chance of losing it after you've invested time and money to market it. So we recommend at least 6 months. You want to put in the address and the county and the assessor's parcel number. Now, when you go into broker zip forms, just like you can in the other zip forms, you can pull in the listing. Once you have it inputted, and it'll type these in automatically. Otherwise, you need to go ahead and input the information. Listing price and terms, if you just input dollars, it will automatically spell out the listing price. So inputting 790,000 types out automatically for you 790,000. Listing terms on here, you know, this is a blank that you can fill in if there's something applicable. Maybe you might have a situation where, not in this market, but in a slower market, that you take a listing maybe higher than you want to, and the seller agrees to reduce that price, you know, by 5% in 30 days or something. You could put that in there. There's things like that that would apply to the listing. That's what you could use that particular section for. Okay, going on to compensation. So this is where you're going to put in the percentage that is offered as a whole. People get confused on this. They think that this should be what we're getting. This is what the seller is paying the brokers for selling their home. So in this case, it's a total of 5%. The other option on this, there's another block there with a $sign. That's if you go ahead and negotiate a flat fee. Rarely do we have that happen. You're always going to usually be putting a percentage in there. If there is a flat fee scenario, obviously that's something you need to review with your manager if you're doing something like that. It's just a little bit out of the norm. The next paragraph talks about that if during that listing period or any extension thereof, that the broker or anybody procures a ready, willing, and able buyer to purchase the property, as long as those terms are accepted by the seller, and provided that the buyer completes it, that commission is due. So that's what that paragraph is saying. The paragraph after that, number 2, is saying, or within 90 days, and again, it's optional as to the time period you put on here. We suggest 90 days. If you guys could mute, that would be awesome. Thank you. So if within 90 calendar days after the end of the listing period or any extension, or after any cancellation of this agreement, unless otherwise agreed, seller enters into a contract to sell this to a prospective buyer who has physically entered and was shown the property during the listing period by a broker or cooperating broker, and an offer is submitted, they are going to be obligated. So if I have this listing agreement and I have a client that I take into it and I show it to them, and they decide to write an offer on the, you know, 1 day after 6 months, my client's covered as long as I provided the seller with a written notice of the names of those prospective buyers. So if you get to the end of a listing agreement and the seller says, I don't want to extend it, I'm going to relist with another agent, then what you want to do is put in writing to that seller the name of the buyers that you've shown that property to, in doing so, you will be entitled to the commission, not the agent who takes on the new listing. Okay.
Hey, Karen, I have a quick question about the calendar days after the end of the listing period.
Mhm.
So I've seen some people leave that blank and some who have written up to 360. So is there a minimum?
It can't be blank or it doesn't apply.
Exactly.
So there has to be a number in there. You could put any amount you want, whatever the seller is willing to agree to. I doubt if a seller who fully understands that paragraph is going to agree to 360 days.
Right.
And what other listing agent is going to want to take that listing. I mean, he risks the chance of, listing that property and not getting compensated if it's one of those prospective buyers. So 90 is a pretty reasonable. 120 days, 90, 120 days is usually what you're going to see in that blank.
Okay.
Okay.
Thank you.
All right. And then the third one is if without broker's prior written consent, the property is withdrawn from sale, whether it's leased, rented, etc., or made unmarketable by a party, or made unmarketable by a voluntary active seller during the listing period. So if your seller says, you know what, I want to rent my property and take it off the market, well, technically he's still obligated to, be under contract under the listing agreement. We have to give him a cancellation. Otherwise, he is contractually obligated to this listing agreement for the 6-month period. Most of the time, it's not always a positive thing to not cancel, but there are cases where you've put in a lot of time and money and the seller's being unreasonable, different extenuating circumstances might be there that we're not going to give that cancellation to the seller because we know that maybe he has an alternative motive to go list it with somebody else. But each situation is individual, and that's what you really have to look at when you run into that type of situation. Okay, if completion of the sale is prevented by a party to the transaction other than the seller, so let's say the buyer prevents it going through, then compensation which otherwise would have been earned shall be payable only if and when seller collects damages, and then in an amount equal to the lesser of 1/2 of the damages. So basically what that is saying is that if, let's say a buyer gets to the end of a transaction, gets total remorse and pulls out of a deal, and that seller goes after that, they remove contingencies and the seller goes after that buyer for the earnest deposit and wins that money, then you can get compensated for your commission based upon the settlement. I honestly have never seen that happen in 30+ years, but that is what that paragraph addresses. Number C, in addition, seller agrees to pay broker $3.95 processing fee. So that is automatically pulled in again on the zip form broker version. So you don't have to worry about it. It automatically pulls it in. D, seller has been advised of broker's policy regarding cooperation with. So now this is talking about that we as a broker have talked to the seller that we're going to split our commission with a cooperating broker, and it's going to be in this amount. So again, it's usually 99.9% of the time a percentage. You could have a flat fee, but normally it's going to be a percentage. And normally we are always offering the cooperating broker 2.5%. If we're taking a reduced commission, that's the company's philosophy and policy on it. So that is what the other portion of the compensation would be. And also just touching on that, in case any of you haven't noticed it, in public viewing sites, they now have to put in what the cooperating broker commission is. That was the result of a settlement between the DOJ and NAR. It was not going to go into effect for about 45 days, but we are now seeing the MLSs feeding that out to the internet sites because they legally are obligated to do so. So when you go into sites such as Zillow and that, you're going to see what the cooperating commission is to the buyer's agent that was never there before. It was only on the our facing side of the MLS. It's now going to be out there to the public because as a result of that settlement, they felt that we weren't disclosing to the consumer the full picture without letting them know that the buyer agent was getting compensated. So don't ever say like you as a buyer, you don't pay commission or it's free or anything like that. Again, that's all the things that were related to that settlement. So and there is nothing we can do about it. We've had agents, I know Charlene has had agents contact her saying we have to fight this can't happen. It's a done deal. It's a settlement, legal settlement, and we have absolutely no say in it. So it's out there, it's live, and we're going to see it more and more as more MLSs start implementing it. Seller, number E, seller hereby irrevocably assigns to broker the above compensation from seller's funds, and they can provide a copy of this to escrow. That's where you get that amendment from escrow that reiterates what the commission is. It's basically saying the same thing here, that the seller is irrevocably assigning those funds to the broker. Number F, seller represents that seller has not previously entered into a listing agreement with another broker. Seller warrants that seller has no obligation to pay compensation to another broker. So these two things are important if you're taking a listing and it's been expired. Or you know that they've been talking to somebody else. You just want to clarify that they don't have an agreement with anybody else. There's no obligation. Maybe they had it listed before and they got a list of prospective buyers. So if you've got an expired listing or one that you're taking over that's just freshly expired, that's one of the important questions to ask your seller if there was a situation like that. And if so, then you need to put those prospective buyers that they were notified by the previous broker into this contract. Okay, so then going on to, where is my arrow?
So, and then for the commission, I'm sure everyone here knows that we're not, you should not take a listing under 5% total, right?
Correct, without your manager's approval on it, right? Okay, so item number 4A, items excluded and included. So this is probably one of the things that has caused so much heartache in deals. And it's so important when you take a listing that you really go over with the seller. Is there anything that you don't want to be included in the sale or anything you want excluded in the sale? Just to make sure and talk to them about, what about the plants out front? What about those fountains? What about the swing set? What about the spa that could be moved? Is that included? Because for sure something's going to happen where a buyer is going to assume that something's included and it just becomes a war. And I've seen really big wars over drapes, like silly little things like that. So first of all, make sure that you address with the seller what they want to include and exclude on the sale of the home. But also understand that in doing so in the listing contract, that's the notification between you and the seller. However, when you go to put it on the MLS and then there's a contract written, the contract is what overrides this here. So, if the seller has said, well, I want to exclude the swing set and the fountains, but you get to the point of an offer and they've included the backyard swing set and the fountains, that supersedes this because the seller is now changing his mind and agreeing to include these things in the sales price. So the purchase contract is going to be the final word on that. But this is for you to know up front what to put in the remarks on the MLS as far as what is included and excluded. And make sure that you do put that in the MLS. I just had a recent one where somebody didn't put it in the MLS, and a lot of confusion and misunderstanding as to what was included and not included. So, okay.
We have a question, Karen,
Yes.
from Nina, and it's regarding, I believe, the commission on the first page. So she'd like to know who's getting paid if you have an expired listing and the previous agent had shown before to a client.
Well, it would be you and the previous agent. So if there was a prospective buyer that came through and you had the listing and Chris showed it, I would register that person as a prospective buyer with that seller. And if Chris came in with that offer 2 days after we expired and it was put together, then we would both get compensated on it. Okay. Okay, on B, this is also another big item that you need to make sure that you pay attention to and you ask the right questions at the point of taking the listing. And the biggest one is this relates to is obviously solar, because we're seeing it on so many properties. It used to be in the old days water softeners. For those of you that have been in the business a long time, that was the big one because everybody used water softeners in the back, and people, you know, people don't think about the things that they're leasing. But particularly as it comes to solar power, most of them today are leased. You know, 15, 20 years ago, people were buying them. Leases were not a popular thing with solar. It was more you either bought them fully or you didn't. Well, there were situations where sellers would totally forget that they were making a lease payment on a solar system or a payment on a finance solar system and not disclose it. And sure enough, you get into escrow and you have a huge surprise because there's a $30,000 lien on the property for the solar that has to be cleared before you transfer title on the property. So asking about solar, you know, do you have, obviously paying attention to if you see visibly they have solar panels, but asking them that question, do you have a solar system? Is it leased or is it purchased? Getting a copy of that contract up front. Don't wait until you get it into escrow. Get those things up front. Because then it allows you to take a look at that agreement. Most solar companies, as I said today, most of them are leased. If they are leased, then what has to be done is that lease has to be transferred over to the buyer. Usually a simple process. It depends on the solar company. Some of them are amazing to work with and some of them take forever. So you want to start working on that now, because if you've got one of those companies that are going to take forever, you want to be proactive on it. And you also want to be able to provide a copy of that document to the buyer as soon as you get into escrow, because it's a contingency of that purchase, is for them to take a look at that agreement and make sure that it's acceptable to them. So it says on here that seller will provide to buyer as part of the sales agreement copies of lease documents and other documents obligating the seller to pay for any such leased or liened item. So really pay attention to that one. Again, it's mostly solar. We don't see alarm too much. Propane tank, you're going to find that, you know, on properties that, you know, in Santa Rosa, way out there. But in your typical tract situation, no. And then water softeners, I haven't seen one of those in a long time. So.
Yeah, I haven't seen water softeners. And the other thing about solar powered lien items is that sometimes depending on the company, the buyer may need to qualify to take over that lease.
Yeah, all of them actually require the buyer to do a credit report.
Right.
And they do have to qualify, but they're pretty lenient as long as they don't have a horrendous credit report. Right. I've never heard of one that hasn't been transferred over. But get that paperwork up front. It's also a document that when you go to input your listing agreement, you can, you know, there's a section that you can upload documents. So that is where you could upload that solar agreement right up front. You know, the more, especially in this market, the more things that you can get done up front with your seller and disclose to the buyer or potential buyers, the cleaner deals you're going to have. And we're running into that right now. So because then that way the buyer has that information up front and can remove contingencies as it relates to those things. Just like we're going to get into a little bit further down, but just like HOA docs, if they order those up front, that's something that can be removed right away and you don't have to wait for it. Okay, multiple listing service. So what is an MLS? I think we all should know what an MLS is, database of properties that are for sale. This just explains to the seller what it is. You know, this agreement was changed. It's been changed several times over the last few years, and it's really to try and get it more in layman's language so that sellers understand what an MLS is and truly understands these different options available to them on how they can list their property and what clear cooperation is. So this section talks about what is an MLS, what information is provided to an MLS, and then it asks what is the broker's MLS. So this is where you put your MLS in here. A lot of people put the wrong thing in here. They put, if, for instance, if you belong to Caneo-CIMI, they put Flex MLS in here. That's not what goes in here. What goes in here is Caneo-CIMI Moorpark Association of Realtors Multiple Listing Service. We can change our MLS from Flex to ChrisNet to whatever at any point in time. That's why it's not the name of the MLS itself, it's the name of the association, what MLS they're using. So that's what should be put in here. If you're SRAR, that should be put in here, and I believe VCCAR is the correct abbreviation on that for Ventura County, for Ventura Regional rather. And then if you are not a member of the local MLS, then you would check this box saying that that MLS is not the primary MLS for the geographic area of the property. We're not going to run into it too much because we co-op and share. We have a data share with CRMLS. So we can cover areas from Ventura all the way down to San Diego and out to Palm Springs and be able to access properties. But there's a couple of pockets that are not part of that CRMLS, such as Antelope Valley, Santa Barbara, and San Diego, the large MLS down there. So, you know, if you're taking a listing in San Diego, for instance, which I highly tell you not to and refer it out to somebody, you should work in your service area. But let's say you took a listing in San Diego and you put where you belong, which let's say is CSMAOR, that is not the primary MLS for San Diego or for Antelope Valley. For Antelope Valley, for instance, it's GAVAR. So you need to mark this box saying that that is not your primary association. And you would have to join those associations in order to list down in those associations, but we have to disclose to a seller if that is not the primary, because what it's saying is that the property may not show in all the MLSs. So we're lucky that we're in CSMAR and VCCAR and SRAR because we are part of CRMLS, so our listings get the most exposure that they could possibly get across the board. Okay, so again, just really stressing with the seller, this is a separate block that they have to initial, and you can initial on behalf of the broker. You don't have to send it to your manager. You act as agent on behalf of the brokerage. So when it says broker/agent's initials, you can initial here. But it's really clarifying to the seller exposure of their property through MLS, what it means to opt out of MLS, and how that reduces the potential exposure of their property to as many buyers as possible. And if you're not listing a property in a local MLS, that there's a possibility that buyers looking for the property, for their property, may not be aware that the property is for sale. So it's just a big bulletin to the seller, seller beware, and just understand all of these different things. Okay, so now we go into a little bit more of the clear cooperation and public marketing of the property and those different statuses that we talked about. So we talked about that it can go in as active, it can go in as coming soon, it can go in as an office exclusive. The first one, 7A, clear cooperation policy, you are never going to mark this box because our MLSs, all of them require that we adhere to the clear cooperation policy. So the MLS rules require that any properties be submitted to the MLS within 1 day of public marketing. So that is never going to ever be marked off. Public marketing with clear cooperation. So this is where it talks about what is public marketing. So they understand that that means putting that property on public facing websites and on our brokerage and, you know, anywhere out there that the public can see it. Coming soon status, impact on marketing. It's advising the seller what this term means and how the coming soon status will impact when and how a listing will be viewable. So that's where that cheat sheet comes into place because it's telling the seller, you're letting them know that if I put it in as a coming soon, this is what I can and cannot do for your property. And then the seller, if they do not want you to utilize the coming soon, then that's where you would mark this block. Okay, in a situation where we have an active listing, obviously you're going to take the listing, you're going to input it right away, and it's going to become live right away. When you have a coming soon or an office exclusive, it is not going to go to the public. You're going to submit it to the board, but we are not going to put it into the MLS. So in those cases, you have to use the form SELM. So that's seller excluding the property from the MLS. And we're going to go over that form and another form, SELI, which is excluding it from the internet when we're done with the listing agreement. So this paragraph D says seller instructs broker to market the property to the public and to start marketing on the beginning date of this agreement, or where you would use this, let's say you take a listing and maybe they want a few days to get the property ready, do a little touch-up painting or whatever, and you're going to put it on the market in 7 days, then that's the date that you would put in there, and you're going to fill out the SELM form that is also going to say the same thing. The listing agreement and the SELM form needs to be emailed over to the board office so that they have record of it when you're doing that type of a situation. Or seller instructs broker not to market the property to the public and that they understand that it will only be direct one-on-one promotion between the brokers and licensees affiliated. So this is the one you would mark if you're doing office exclusive, because it's saying that they understand it's not going out to the public, but that you are going to market it to the 400 and some agents that we have within Century 21 Everest. And then E, whether 7D1 or 2, the ones we just talked about, is selected, that the seller understands and agrees that should any public marketing occur, that the property listing will be submitted within 1 day. It used to be 2 days, so for those of you that are still acting on that, everything needs to get in within 1 business day. And again, that's business days, not calendar days. So if you take something on a Saturday, it just needs to be in 1 business day, not a calendar day. Clear cooperation policy does not apply. That is never going to be marked because we have clear cooperation policy. We adhere to that with all of our MLSs. Okay, number 8, MLS data on the internet. So this is the one where it talks about excluding the information from the internet. I rarely, I can't even think of when was the last time someone used an SELI, because it has to be signed by the brokerage, and I can't even remember signing one. So rarely is this ever used because most people want to have it in the internet, right? They want it on Zillow and everything else. But the seller can instruct us not to display their property address on the internet and just not put it in there at all. The other one, that if you look down at B2, it says automated estimate of value. You know how Zillow does that? Well, seller elects to opt out of certain internet features as provided by CAR or the equivalent form. What this says is that basically, yeah, we can exclude you from the internet and all those different things, but we can't control once things do. I just want to mention this because it's come up in different situations. Once we feed out to Zillow and everything else, we can't control what they do with that data. We can't control what they do with those pictures. We've had people that have sold a home and the buyer wants it removed from the Zillow, because you know how Zillow is wonderful at keeping things up there that haven't sold or have sold, and they're still up there. And they're like, I don't want my house, you know, my pictures on there, whatever. We can't control that. That once it goes out there, you know, it's just like us giving the data to everybody years and years ago. Once that horse leaves the barn, it's done, it's gone. We can't control it. So just an FYI on that. But very rarely are you going to use the MLS data exclusion on the internet. I very, very rarely see it. Seller representation. So seller represents that, unless otherwise specified, that they are unaware of having a notice of default on their property. Why is that important? Because if they have a notice of default on their property, then you need to use the notice of default purchase agreement, because that means that they're heading towards foreclosure. It needs to be disclosed. If there are any delinquent amounts due under any loan, what do they owe? They have to disclose to you if they have a first, a second, a third. If they are in bankruptcy, they need to disclose that. If they're in bankruptcy and you're taking a listing, that bankruptcy trustee has to be involved in the sale of the home and approving the sale of the home. If there's any litigation, arbitration, anything like that, you know, most of those things will show up when you have a preliminary title report done on the property, but not always. It could be something that just happened, and when title runs the examination, the chain of title and everything, it hasn't popped up yet because that lien could have just been placed on a day or two ago or a week ago. They're about a few days behind from what's publicly reported and title examining and doing that. So you want to make sure that you ask the seller these questions. Is there anything I need to be aware of? I do need to know what liens you have on the property. So I'm assuming you know, obviously you have a loan on the property, that's a lien. Do you have an equity line? People forget about equity lines all the time. So sometimes people take out equity lines and they never use them. So there's a zero balance and they think, oh, I don't need to worry about that. Yeah, you do, because once you take out that loan, a lien is placed on your property and that lien has to be removed. So with that, what I highly recommend to everybody is that when you take a listing, at the time you take a listing, or right before you take the listing, if you know for sure you're getting it, have your title company run a preliminary title report on the property. It's not something you want to use loosely. It takes time and money for the title companies to prepare them. But if you're listing a property, you want to know upfront what you're dealing with. If there's I've seen, you know, I was in escrow for about 7 years back a ways, and I've seen things pop up that they never mentioned, like child support, or maybe they owned a business and they had a personal property lien from a business that they, you know, sold or closed 10 years ago and never realized that that was a lien that was put on their property because they don't get notification of it. So you want to know about those things as early as possible so that you can, especially in this hot market where things are flying off the shelf, we want to cut all those time frames down to get our buyers engaged and moving forward as quickly as possible. Order a preliminary title report, find out what's on there, and if there's issues that need to be cleared, get on top of them right away and start working with the seller and doing that. Okay, broker and seller duties. Let me just scroll down here a little bit. Okay, so broker agrees to exercise reasonable effort and due diligence and to achieve the purposes It's talking about advertising and marketing the property, disseminating information about the property, and disclosing to any licensing, making an inquiry, the receipt of any offers of the property, and offering prices of such offers. So this is just talking about what our responsibility is with that seller, that we agree to present all offers received on the property, that we agree to present them to the seller as soon as possible. I'm just going to touch on as soon as possible a little bit. If you go on vacation and you're not available, you need to have another agent available to be there to submit offers to your seller. It's our obligation as a brokerage to be as efficient as possible and to present those offers as soon as possible. We can't say, oh, I'm out of town, let's do it tomorrow. They need to be gotten to the seller right away, unless the seller gives you instructions contrary to that. Seller agrees to consider offers presented by the broker and to act in good faith, making it available for showing, and responding to inquiries about the property. Number D, investigation and reports. Again, in this market, it's always a good idea to try and get things done up front. You might want to talk to your seller about the potential of having an inspection on their property prior to listing it so that they know what you're dealing with. HOA docs, I talked about that earlier. That's something that can be done up front, or the termite inspection is something that can be done up front. So if the seller wants to do those things and wants to front the money to do those things rather than wait for them to happen during the offer, it's certainly something that they should think about. And in here it says that the seller is advised that there may be benefits to obtaining any required documents prior to entering escrow, which may include but not be limited to potentially being able to lower cost in obtaining them, avoiding potential delays or complications due to late or slow delivery of such documents. And HOA documents is a perfect example of that, because a minimum time for HOA docs, I think, is probably 7 to 10 days. And that's a contingency and that buyer has until they get it, receive it, and they have that time frame to do so. So that is something a seller pays no matter what, whether it's an escrow or not. And it's something that can be ordered ahead of time. So in this market, that would probably be something you might want to seriously consider encouraging your seller to do.
Karen, I have a question, since you were in escrow for so many years, regarding homeowners association docs. So, and I know when you order docs, don't they need to be certified or something like that?
Well, the way it used to work a long time ago is that every HOA used to do their own HOA docs. They, whether it was Emmons or whoever the company was, they always did it. Well, then came along these third-party companies that would do it for the HOAs, and it was much more cost-effective for them. So they started using these condo cert companies, and it's not really that they're certified, they're just third-party companies that do the service for the HOA. So unfortunately, the problem that has occurred with that is that it has increased the delivery time of HOA docs. Used to be a lot faster when the HOA company was doing it, but now they're like, well, we don't have to pay staff to do it and make all those copies and put all these huge packages together. We can just send the update to these companies and they supply it. So escrow officers now know what companies each HOA use, and they order those from them. Does that answer?
Yes, and there's no expiration date on these documents?
There's no expiration date on them, only that, for instance, in the purchase agreement, it says that the seller is to provide the most recent 12 months of minutes. So if you have a property that, has been on the market for 3 months and you got the HOA docs ahead of time, you're going to need to get the last 3 months of minutes. So that would really be the only thing, unless they've, usually budgets and that they do once a year. So minutes is probably going to be the most important thing to get updated. And that's important because minutes are going to address if there's special assessments coming up, or if there's maybe litigation that's occurred since the time that they got those documents. While on HOA documents, I highly recommend that if a seller offers to give you what they have, that you encourage the seller to pay the money for the HOA to prepare the documents, because there's so much liability of, someone missing something very pertinent that they got in the mail that they don't include in that package that they deliver to the buyer that could come back to, bite them later on. So it's always best, just like an NHD, third party, let someone else take the responsibility, so you as the seller aren't getting caught up in the fact that you forgot to deliver a document to them that was pertinent, that now has an effect after it's closed escrow and they want to sue you over it. It's just not worth it. Okay, deposit. Brokers authorized to accept and hold on seller's behalf any deposits. I think all of you have probably heard, and we have a default in the purchase agreement that all deposits should be wired directly to escrow. We don't take deposit checks like we used to back in the old days. We used to take deposits, checks for everything and put them in the trust account. And DRE has just become so all over that type of thing that we don't want to have funds going into our trust account. So those funds should be wired directly to escrow. Agency relationship, this just relates to those two forms that we covered in the very beginning, the PRBS, the possible dual agency with buyer, and the disclosure regarding real estate agency. So it's just reiterating that. It's reiterating that it's going to be confirmed what the agency relationship is. So in your purchase agreement, that very first section, well, they've moved it now, but that confirmation of agency is built into the offer itself. So that's where it's going to be confirmed, and just again, talking about potentially competing buyers and sellers. Security, insurance, showings, audio, and video. Okay, lots of properties today have audio and video. It should be disclosed to potential buyers walking through there. And you guys, you've got to keep that really front of mind, that there are cameras and videos everywhere. I had a listing a couple years ago and my seller called me cracking up, just going, oh my God, like they stood at the front door and I heard everything they said about what they thought about the property. So just make sure that when you're done showing a property, take them out to the street, on the other side of the street, and discuss anything about that property. Make them aware. If you take a listing, we actually have a little flyer that you can put throughout the property that says, please be aware, you're being videotaped, it should be disclosed. Also, if you're having a home inspection, that's another situation, advise the inspector that I had one where my son bought a property and a little old lady was in it, and the kids were watching her because she lived on her own, and there were cameras everywhere. And I told the inspector, if we walked in, you know what, just don't even go through, do it. And we're not going to sit in the house and go over the inspection. We're going to walk out and do it elsewhere. So be aware of those things, because you don't want to be sitting in the house and talking about an inspection and someone is hearing everything that they're saying if you're representing a buyer. And on the other side of that, you just want to make sure that that it's disclosed to everybody. So the other thing in here is that it also notifies the seller that there may be third parties taking pictures, such as inspectors, or maybe you have a buyer that's taking videos of the property. So it just addresses that. It also is telling the seller to make sure that they take precautions as far as safeguarding and protecting their valuables, not making them accessible, making sure their insurance covers that, because our insurance doesn't cover that, that type of thing. So that's what this paragraph is all about. It's really an important one in today's world, and I think we all forget about it a little bit. Okay, photographs and internet advertising. This basically talks about the fact that in order to effectively market it, we are going to provide photographs, virtual tours, etc., available to buyers. And it basically, in a nutshell, this talks about that we are going to the seller aware of that. There is a section in B where it says, there's a box there, seller instructs broker to publish in the MLS that taking of the images is limited to those persons preparing appraisal or inspection reports. Rarely are you going to ever mark that again, because most sellers understand the need of getting everything out there to the public. Safe key safe and lockbox. Well, we're not using those as much because we're doing so much by appointment, but we are using them some. So this just talks about the fact that they're going to permit a lockbox on the property. If they don't want a lockbox, there is a block here to mark if they do not want a lockbox installed on the property. The last sentence in this paragraph is really important. If the seller does not occupy the property, the seller shall be responsible for obtaining written permission for use of it. So if there is a tenant in the property, that tenant has to be in agreement to have a lockbox on the property. And there's a form called the KLA, key box, I forget what the L stands for, authorization, but that form has to be signed by a tenant if it's tenant occupied, whereby they are agreeing to have a lockbox on the property as well. Sign, this is pretty simple. Seller does or does not authorize a for sale sign. Equal opportunity, that we're going to comply with all the federal, state, and local anti-discrimination laws. Attorney fees and any action between the seller and the broker as it relates to this particular to the agreement, that the Century 21 Everest addendum is made a part of this agreement. So it's a reminder to you to make sure you incorporate that form when you do the paperwork. There are a couple of situations where you have to have other forms as well. So REOs, which is bank-owned properties, we're not seeing that right now. Short sale, we're not seeing that right now. Trust advisory, we're seeing that a lot because a lot of people today have their homes in trust. And we're going to go over a couple forms that relate to that. But you want to mark trust advisory if the property is in a trust. Secondly, you want to mark seller intends to include a contingency to purchase a replacement property as a part of this resulting transaction if the seller does intend to do that. And then you're also going to need to do the appropriate form when you get an offer as far as that goes. So where's my, sorry, my arrow here. Okay, down to management approval. This just talks about that even if a seller signs this agreement, that a manager or broker of this company can if they do not agree to the terms of it, they can cancel it. Successors and assigns, this is saying that if the seller, for instance, passes away, say it's in a trust, the successor trustee is still obligated to this contract, so it continues. Dispute resolution, that's as you see it in the other areas as it relates to this. Mediation, they're agreeing to do mediation before they go to arbitration or court, that this is the entire agreement. And then at the very bottom, representative capacity. So representative capacity, we're going to go over that form separately in a minute. But if you have a seller on your listing that is in the name of a trust, is an LLC, has a power of attorney that they're using, or as a probate estate situation, you're going to need to use the RCSD form, and you're going to mark this box representative capacity.
Karen, we have one question.
Yes.
So if you have a listing agreement, it's not in a trust but it's under an actual person, and the prospective seller passes away, what happens?
The heirs then would be obligated to continue it.
And if there were no heirs or will, it would then go into probate, correct?
Right. Mm-hmm. Right. Okay, seller advisory. This basically just talks about disclosures as it relates to the fact that the seller has to disclose to the buyer certain things that are required by law. For instance, the TDS, the NHG, the earthquake. It talks about they have to disclose, you know, things like if it's located within a mile of a military ordnance location, if it has mellow roofs, all of those types of things, that the seller has to disclose all of these things. In addition, number C, seller has to disclose if there's been any deaths in the property in the last 3 years, if it has an HOA. So this form basically just discloses to them that they have to disclose. Withholding taxes, that may or may not apply to them if it's their personal residence that they're selling. It will not. If it's their investment property, then withholding taxes would apply. There's a form that escrow is going to have them fill out. So that's an important thing to understand and know. If somebody's moving out of country, there's federal withholding taxes. So the California one is 3 1/3 and the federal is 10%. So if you have someone who's selling a property and moving to England, they're going to have funds withheld from their proceeds that are going to be given to the federal and state levels until they file their tax returns. If they don't owe what was withheld, they'll get that money back. But if they don't, they will keep that money and then collect whatever additional they owe at the time that they file their taxes. So if you have a situation like that you're concerned about, talk to your manager so you fully understand it. It talks about just discrimination again, government required repairs. So, you know, things like smoke alarms and carbon monoxide, those are state requirements. So we have to do those, the seller has to do those. It also talks about if there's city and county government things such as City of LA, if the property is within the City of LA, they have to do the low flow toilets and shower heads and gas shut off, etc. In our areas, we basically have just city report for City of Thousand Oaks, Port Hueneme, Ventura, and Oxnard. And then we also have the sewer lateral for Ventura. So those are local things that we have to deal with. So the seller is, and this is a great time to bring those things up and explain them to the seller. And then pre-sale inspections, again, it just talks about those, that it's always a great idea to get those inspections done, you know, before they take the listing, just to kind of, you know, take care of issues ahead of time. And then post-sale protections, it's telling the seller it's a good idea to have a home warranty, and we highly recommend a home warranty on everything. Safety precautions, again, it's just reiterating that they put away their, you know, personal property and belongings, cash, jewelry, drugs, etc. And expenses that you, not the broker, are responsible for fees and costs to comply with your duties and obligations to the buyer of the property. So that is the seller advisory. The California Consumer Privacy Act advisory, I think Fredo did that.
Yeah, we covered that yesterday.
Yeah, so that is, you know, same thing we run into all over the place as far as California consumer privacy, and they need to sign that one.
And guys, if anybody has a question, please use the chat box.
Okay, seller instruction to exclude listings. So this is the SELM, and this is the one you're going to use when, for instance, if you're going to not put the property in the MLS for a week because they're getting the property ready. This form has to be completed and sent over with the listing agreement to the board office. It asks you to fill out what MLS participant you are. So in this case, we use CSMAOR. It talks about, again, just reiterating the benefits of the exposure through the MLS. And if they are not going to put in the MLS, what they're, you know, risking as far as not giving it full exposure. This number 3, the MLS, we're never going to fill out, does not require, because our MLSs all do the clear cooperation policy. And this is just, again, reiterating public marketing. And D, MLS has not adopted. We're not going to mark that one because ours has. So then getting down to 4, seller instruction to broker to exclude property from the MLS. This is where you're going to either choose A, do not market the property immediately, begin marketing it to the public on. So if they say we want it off the market for a week, this is where you're going to put the date in. Or do not market the property to the public during the entire listing period. More than likely, you're probably not going to be in a situation like that, but you might. So those are your 2 options there. So that is the SELM. It goes with the listing agreement and just, again, just reiterates all of this over and over. We're trying to get that message through the seller and cover ourselves as far as what it means to them if they exclude from the MLS. And then this one, again, it's the exclusion from the internet, which I think you're rarely going to ever use. And it does the same thing. It reiterates all of what we already kind of covered in the listing agreement to an even more extent. And it puts in here that, you know, we have no control over those third-party websites. So once you know, once things are out there, we can't control it. Okay, so any questions on the listing agreement, those forms, that type of thing? Just put them in the chat box and we'll answer them for you. Okay, representative capacity signature disclosure for seller representatives. So I mentioned this earlier. That was the box that you were going to mark at the bottom of the listing agreement. If you have, oops, sorry, one of a couple situations. Oops, sorry about that. Hold on one second. So these are the situations. So if it's in a trust, if it's in an entity, power of attorney, or estate. So let's talk about each one. So the first one is a trust. So the first thing I want to say is that the name of the trust is not Karen Betancourt, trustee of the Karen Betancourt Living Trust. When you have a property that is in the name of the trust, and let's just use mine, okay? If I'm selling my property, it's going to be in the name of Karen Betancourt. If I have the property in my trust name, Karen Betancourt is not who the seller is. My trust is the seller. So anywhere it says seller on your paperwork, whether it's a listing agreement or a purchase agreement, that seller name is Karen Betancourt Living Trust. And if it has dated, which mine does, that's the legal name of the trust. And if you have someone who has the property in a trust, you can ask them for what's called a copy of, either look at their full trust or look at they might have a abbreviated version called the certification of trust. And on that form, it tells the legal name of the trust, who the trustees are, what the powers of the trustees are, and if the trust is revocable or not. The other way of finding out the correct name of the trust is to have title pull the most recent grant deed that deeded the property from Karen Betancourt to the Karen Betancourt Living Trust. That way you'll have a copy of the deed and that should be the accurate name of the trust, okay? So just remember, if you have a property in the name of a trust, the seller's name has got to be the trust. Otherwise, if I go ahead and sign a listing agreement with you and I have my property in the name of my trust, that's not a valid listing agreement because it's between me and I don't have the power as an individual to sell my property. My trust does. So you don't have a valid listing agreement with me. So in order to have a valid listing agreement with me, everywhere where it says seller, it should say Karen Betancourt Living Trust. Now what this form does is it enables me as the trustee to sign on behalf of the trust. Okay, so let's talk about the other ones and then we'll go on. So the second one is an entity. So is it a corporation? Is it a limited liability? Is it a partnership? If it is, then you need to mark that box and the person who has the authority to sign for it, for instance, on a corporation, would be the president usually. So that is who's going to sign this form, and that's who's going to sign. Once he signs this form, now is saying that I'm going to sign on behalf of the corporation. So then that person would sign all of the paperwork. Power of attorney. You might have a situation, maybe it's a relocation, husband's gone ahead, you have a power of attorney to sell the property and for the wife to sign on behalf of the husband while he's out of town. Number one, it should always be a specific power of attorney. Although this form says that this gives them the power to act on their behalf pursuant to a general power of attorney, in real estate, you're never going to use a general power of attorney. I wish they would just take that off. It needs to be a specific. And title will not accept a power of attorney unless it's a specific power of attorney. And that means that it's specific to this property. Because a general power of attorney gives general power over bank accounts and insurance policies and things like that. But specific gives power as it relates to the purchasing and sale of real estate. So it needs to be a specific power of attorney. And then estate would be if it's a probate or conservator situation, and that's where you need to put the information from the documents from the court, the case number and that. And that's when you would have an administrator or an executor of an estate. So, and if you're dealing with that, again, all these things, if you're dealing with an entity, the seller is the name of the corporation, not the president of the company. The estate, it's going to be the estate of Karen Betancourt is going to be the seller, not Chris Malamed, who's my executor. Okay. So what this form does then, it says that up here, this is a disclosure, and that's down below, I'm sorry. Let's see, where's the wording on it? So this is where they sign. So if it's a trust, I'm going to sign it here by Karen Betancourt and date, and it says Karen Betancourt, and my title is going to be trustee. If the trustee has passed away, then that would be successor trustee, whoever, whether it's a child or whatever, is taking over as successor trustee. If it is a corporation, then you can see the next line says managing member, partner, attorney. In fact, that's where they're going to sign.
Can you show my mom how to?
Oh, can you mute?
Yeah, I got it.
Got it. Thank you. Okay, so basically this form then, once they sign this, they are stating that they, right here is what I was looking for. The seller's representative represents that the trust entity or power of attorney for which that party is acting already exists. So they are stating that they are indeed the person who has the power to act on behalf of these entities, and as such, they can go ahead and sign the paperwork. Now, when they go and sign the paperwork, I can sign it Karen Betancourt. I'm not going to sign it Karen Betancourt Living Trust. I'm going to sign Karen Betancourt. Because now I can sign it Karen Betancourt because I filled out this form.
Okay, that was going to be my question. So so on all of the documents, it doesn't have to be Karen Betancourt trustee.
No, because I've established that in this form.
In the RCSD.
It used to be, we had to do that on, we'd have to write Karen Betancourt trustee,
Everything.
Karen Betancourt, blah, blah, blah. No,
Right.
we don't have to do it. That's what this form is for.
Awesome.
Okay, so once they sign this, you want to have them sign this first before they sign anything else, because they're establishing that they are the authorized signer.
Right.
And once they do that, then the initial is going to be KB and my name's going to be Karen Betancourt.
Perfect.
I'm acting on behalf of the trust, not as an individual at that point.
Okay, perfect.
Okay. And then trust advisory, this goes along with the trust. And what it talks about is there are certain things that a trust is exempt from when selling a property. So I think the bottom line of this particular form, you can see there's a lot of not exempt on here. The one thing that they're exempt from is the TDS if they are not living in that property. If I'm living in my property and it's in a trust, I still have to do a TDS. If I have passed away and my son is the successor trustee and he's never lived in the property, he's exempt. The trust is then exempt from doing a TDS. A lot of agents think because it's in a trust, they're exempt from a TDS. That's not correct. If the trustee is alive and living in that property, they are not living in that property, they need to do a TDS.
Karen, I have a question, I'm sorry.
Yes.
So will the trust information be listed on the preliminary title report?
Yes, when you get a preliminary title report, right where it says how they're holding title, it's going to have the name of the trust. Yep. That's one of the things they're going to research, and they're going to research that it was properly deeded into that trust. If it wasn't properly deeded, sometimes people do their own grant deeds, they don't do them properly, then it'll reference the fact that it's showing in the name of the trust, excuse me, but something has to be rectified on the transfer of title. But yes, it will show up on the very first page where it says what the ownership is.
So Kathy had a question regarding TDS. Kathy Boyles, can you elaborate? Just put it in the,
Okay, can you hear me now?
Yeah. I
Okay,
can.
so I have something coming up, hopefully, that, and I always like to have, even if they're exempt from the TDS, I always like to have them do it just for the heck of it and say, no,
Yeah,
you know, we don't.
Doesn't hurt.
You know, what happened is the trustee passed away. The successor trustee has now moved in, and he intends to stay there for a few weeks or months while he clears out the property before he sells it. Seems to me that that makes him now liable to do the TDS in full, or?
Yes, because and if you read the one section here, it says if the property is placed in a trust, a trustee must complete a TDS and other disclosures that would be required of a regular owner if the trustee is a natural person and the trust is revocable and the trustee either is the former owner or was an occupant in possession of the property within the preceding year. So if it's a trustee or a co-trustee, it's a trustee. So,
Yeah,
yes,
it's one of the successor trustees.
yeah.
And,
So yes, the answer is yes, you're right.
thank you, that's what I thought.
Yep, yep. And it's always not a bad idea, like you said, do the TDS no matter what. I
Yes.
love that, Kathy. Always thorough, as you have always been.
Thanks, well.
You are totally.
Let's see if I remember all this new stuff now.
I know. So just, that is really the most important thing to know on this particular form is that as it relates to the TDS, because pretty much everything else, they're not exempt, okay? And then the coronavirus. Okay, gosh, are we almost done with peds? Tell me someday soon, right? I know, I'm sorry, you guys. It's just such a nightmare to do these, but we still have to do them, and God only knows if we'll have to do them after June 15th. I think we probably will, just because of liability issues, but we haven't heard anything from CAR as yet. But Fred went over this one. It's no different than the one that you did for an offer, only this one, you're using the seller one, you're doing it at the time of taking the listing, and it's explaining to the seller about COVID and, basically the same thing as the other form, it's just for a visitor. So that is the other form that we have to fill out. And then last but not least, in the world of many offers, this is a form that some of you may or may not know about. Unfortunately, it only goes to 5. And unfortunately, in some situations, we've had 30. So, but this does kind of help you, help your seller if you don't have a spreadsheet yourself to go ahead and break down the pros and cons of the different offers that you have gotten as it relates to, purchase price, deposit, possession, contingency timeframes, if they have to sell a property or not, that type of thing. So it's a great little form that kind of condenses it for your clients, because I know getting all of these multiple offers can be very, very overwhelming. So. So that is the end of listing. Do you have any other questions?
No questions, but well, first of all, I'm very impressed with Karen Betancourt. I mean, you went through all of that with a delay and we're done before 11 o'clock. So,
There we go.
okay. Talk about a professional. And then Nina was sharing with everyone that I believe for the multiple offer page, that's what you're referring to, that there's one on Glide that is super easy.
Oh, good to know. I didn't know about that one. Thanks for sharing that.
Yeah, so I'm going to have to talk to Fred about that.
Okay.
For
Yeah,
sure.
definitely. Yeah, that's awesome. Okay, well, thanks for joining us. And tomorrow we'll be going over more buyer documents.
Yeah.
Fred's doing that. So we'll be
Yeah,
going over
Fred's
a lot
doing
of
that.
disclosures. So you'll be sending those out tonight. And again, sorry for the little delay there, but I'm glad everybody hopped on and I hope this helped you a lot. And if you have questions, let us know, let your managers know. We're here to help you.
Yep. So
All right.
I mentioned it to everybody, everyone who's online. I'll get this recording to my early birds, my true attendees today. And then later tonight, I'll send out tomorrow's documents along with the 2 documents that for the Clear Co-op for both boards that Karen was referring to earlier today. All right.
And we'll see you at
All
Summit.
right.
Just
Have a great
few.
day. Thank
All right.
you. See you at
Bye.
Summit.